In this lecture, we shall discuss natural justice. Specifically, we shall discuss the Nemo Judex in Causa Sua rule of natural justice. The Nemo Judex in Causa Sua rule of natural justice. The Nemo Judex in Causa Sua rule is also referred to as the rule against bias. It is a rule that a judge must not be a judge in his own cause. It is a rule that says that the judge must be impartial and act without bias. It is a rule that says that a decision maker should not have a financial interest or a pecuniary interest or a relational interest or a proprietary interest in the subject matter of the decision that he is about to participate in the making of the decision in respect of. So that is the rule against bias. In other words, if a judge is adjudicating upon a matter and it comes to light that the judge has any form of interest in the cause or matter, the judge must recuse or decline to take part in the making of the decision. If the judge participates in the making of the decision, then the whole decision becomes null and void. So that is Nemo Judex in Causa Sua, that the judge must not be a judge in his own cause. This rule is so important that if a judge has an interest in the outcome of a matter, and he participates in the adjudication upon the matter, the whole decision becomes null and void. The whole decision becomes null and void. So we have mentioned clearly that a judge must not have an interest in the outcome of the matter. But the question is, what are the kinds of interests that when a judge has in the outcome of a matter, the judge must decline jurisdiction? What are the categories of interest that, if it is established that a judge has that nature of interest in the outcome of a matter, then the judge must recuse himself and not participate in the decision-making process? The first example is a pecuniary or financial interest in the outcome of the matter. So the rule is that if a judge has any form of pecuniary interest in the outcome of a matter, however small that pecuniary interest may be, that judge will be disqualified from acting as a member of that particular panel. Regardless of how small the pecuniary interest in, it would disqualify a judge from deciding the matter, even though it may not even be proved that his decision was in any way affected. All that is important is that, remember, that justice must not only be seen to have been done, but must be seen to have been manifestly done. Therefore, regardless of the small interest you have in the outcome of the matter, we shall ensure that you decline jurisdiction in respect of the matter. It is important for you to bear in mind that there's no requirement for it to be established that the judge was in any way influenced by that pecuniary interest. All that is important is that as soon as you have any pecuniary interest, you are supposed to decline jurisdiction, regardless of how small such pecuniary interest may be. So the first case we shall use to demonstrate this is the case of Dimes versus Grand Junction Canal. This decision is dated as far back as in 1852. So Dimes versus Grand Junction Canal is reported in 1852, 3 HLC at page 759. Now, in this case, the Chief Justice, Lord Cottenham had shares in a company, and he had granted that company was a party to a suit, and Lord Cottenham had participated in the hearing and made some orders in that particular suit. And the question arose as to whether the fact that he had a pecuniary interest and held shares in that particular company was sufficient to render the decision null and void. Now, it is important to note that the person in this case was the Lord Chancellor. And definitely, even if he has any financial interest in the company, how much influence can that small money or shares have on his influence? But the question has still arisen about whether we can quash that whole decision based on the fact that the Lord Chancellor had some shares in the company. This is what Lord Campbell held in the case. He held that no one can suppose that Lord Cottenham could be, in the remotest degree, influenced by the interest that he had in this concern. But, my lords, it is of the last importance that the maxim that no man is to be a judge in his own cause should be held sacred, and that it is not to be confined to a cause or matter in which he is a party, but applies to a cause in which he has an interest. Since I have had the honor to be Chief Justice of the Court of the Queen's Bench, we have again and again set aside proceedings in inferior tribunals because an individual who had an interest in the cause took part in the decision. And it will have a most salutary influence on these tribunals when it is known that this High Court of Last Resort, in the case in which the Lord Chancellor of England had an interest, considered that his decree was on that account a decree not according to law and was set aside. This will be a lesson to all inferior tribunals to take care not only that in their decrees they are not influenced by personal interests, but to avoid the appearance of laboring under such an influence. So it is clear from Dimes and Grand Junction that even a case in which the Lord Chancellor of England participated in and had an interest in, they went as far as holding that the decision is supposed to be null and void. And this case of Dimes and Grand Junction is dated as far back as in the year 1852. It should tell you how long this principle of Nemo Judex in Causa Sua has been held as part of the common law. Now, apart from the case of Dimes versus Grand Junction Canal, another case that is very instructive on pecuniary interests is the case of Frome United Breweries Company versus Bath Justices. This case is reported in 1926, Appeals Cases, page 586, specifically at page 590. And this is what Viscount Cave observed at the said page, and I quote, My lords, if there is one principle which forms an integral part of the English law, it is that every member of a body engaged in a judicial proceeding must be able to act judicially. And it has been held over and over again that if a member of such a body is subject to bias, whether financial or other, in favor of or against either party to the disputes, or is in such a position that a bias must be assumed, he ought not to take part in the decision or even to sit upon the tribunal. So we have seen again in this case of from United Breweries Company versus Bath Justices that as soon as a person has an interest in any case, that person is not supposed to participate by sitting on the tribunal to take part in the decision-making process. And then also is the Ghanaian case of Attorney General versus Salah. And you see this in the second volume of Jandor and Griffiths at page 487. You'll notice that in this case, the majority view of the Supreme Court was that pecuniary or proprietary interest, however small in the subject matter of a dispute, disqualifies a judge. So we have seen three cases that have all held that if a judge has any form of pecuniary interest, he's not supposed to participate in the decision-making process. We've seen the case of Dimes versus Brand Junction Canal. We have seen the case of From United Breweries Company versus Bath Justices. And we have seen the case of Attorney General versus Salah. They all maintain the same position, that if you have any pecuniary interest in the outcome of a matter, no matter how small it is, you should not participate in the decision-making process. So pecuniary interest is one of the ways in which a judge will be deemed to be a judge in his own cause. Another example or circumstance under which a judge will be deemed to be a judge in his own cause is when the judge has predetermined the issue. It means that when a matter comes before you as a judge, you are not supposed to predetermine the issue when you have not had the benefit of looking at the entire evidence of record before you can arrive at a conclusion judicially. So if you are a judge and a matter comes before you, and even when the parties have not even said anything, you tell one person that I will make sure that you go to prison on this particular matter. Now, that statement made by the judge amounts to the fact that he has even predetermined the issue already. He has already made up his mind on how he's going to adjudicate upon the case. In other words, no matter what you do, no matter the evidence you bring, you have already predetermined the issue. So it will not be right for the court to allow that particular judge to adjudicate upon that particular case because he has predetermined the issue. And if he goes ahead to adjudicate upon that case, he's going to be biased. He's going to adjudicate upon his own cause. It means that when a matter comes before a judge, the judge is supposed to approach the issue with an open mind and rely on only the evidence led at the trial, and he should not enter into the arena of conflict. And on this, I refer you to the case of Republic versus High Courts, Denu, ex parte Agbesi Awosu II, into bracket number 1. Nyonyo Agboada, Sri III, interested party, reported in 2003, 2004, Supreme Court of Ghana Law Report at page 864. I refer you to the number 1 and the number 2 of these cases, all reported in 2003, 2004, Supreme Court of Ghana Law Reports. Republic versus High Court, Denu, Ex parte Agbesia also the second, number 1 and number 2, reported in 2003, 2004 Supreme Court of Ghana law reports. In that case, you will see how the Supreme Court held that a decision maker should approach the seat of justice with an open mind and not enter into the arena of conflict. You will see in that case that if a decision maker has foreknowledge of the facts and he's showing that he has already made up his mind, it should be a ground for bias and the judge will be made to recuse himself from hearing the case. So you've seen pecuniary interest, you've seen predetermination of the issue. Next one is appeals. Appeals. It means that if you are a judge and you sit in the high court and you have adjudicated upon a particular matter, and at the time that the case comes before the Court of Appeal, you were part of the judges who heard the case at the trial court, you are not supposed to participate in the appeal. Because it means that you go and then you'll be adjudicating upon a case that you yourself, you have already adjudicated upon. So appeals, the rule is that a decision maker should not be made a part of his own appeal. And on this, the case of Quest versus Quantrin and others, reported in 1961 Ghana Law Reports, page 605, is very instructive. Quest is spelled Q-U-I-S-T versus Quantrin, K-W-A-N-T-R-E-N-G, and others, reported in 1961 Ghana Law Reports at page 605. And this is what the court held in holding 1. Now, before I deal with the holding, it is important to give a brief of the facts as captured in the head notes so that we can situate the holding in a better perspective. Now, the facts that can be gathered from the head notes are as follows. The suit between the parties came before Oleinuje in 1958. The judge indicated that he knew the family of the parties very well, and he offered to settle the disputes. He then adjourned the case to be taken before another judge so that the parties could use his services if they so desired. The parties apparently were not interested in a settlement. Rather, the case was discontinued and a fresh writ filed in the local courts for substantially the same reliefs. Oleinuje did not see the parties again, nor hear anything about the matter until the present appeal came before him. The plaintiff respondent objected to his hearing the appeal on the ground that in view of the offer he made to settle the earlier suit, it is improper for him to hear the appeal. And this is what the court held in holding 1. The fact that a judge has tried to promote reconciliation between parties and has failed is not enough to make it improper for him to hear the case between the same parties. Otherwise, there will be no point in the provisions in section 84 and 85 of the Courts Acts of 1960 CA 9, which directs officers of the courts, including judges, to encourage and facilitate the settlement in an amicable way without recourse to litigation of matters in difference between the parties. Nor is the fact that a judge knows one or other of the officers, nor is the fact that a judge knows one or other of the parties sufficient reason why he should be debarred from hearing their case. If it were so, very few cases can be heard by judges born and bred in Ghana. So the court in the case of Quest and Quantrin is saying that the fact that Onenuje earlier advised the parties to try settlement does not preclude him from being a judge in the matter. And further, the fact that a judge knows the family involved does not preclude a judge from hearing the matter. Because if that were so, only few judges would be able to adjudicate upon cases in Ghana. And I think I agree with Onenuje. Because think about it. In Ghana, for example, when the only faculty at the time was legal for a very long time, it means that all the judges that will end up being judges in Ghana would have definitely gone through the faculty of law. They will know people in the faculty, they will know the lecturers. And so if the lecturers appear before them and they say that because they know them, then they are going to be biased. Onenuje is saying that the mere fact that you know somebody who is a party in the case is not sufficient to say that you should be recused from hearing the case. This is the case of Quist versus Quantering and others, 1961 Ghana Law Report at page 605. So far, we have seen a number of ways in which a judge can be deemed to be a judge in his own cause. We have dealt with pecuniary or financial interests. We have dealt with predetermination of the issue. We have dealt with appeals that a judge should not be a part of his own appeal. And we have also dealt with the fact that a judge is not supposed to have foreknowledge of the facts. It means that if you are a judge and then you already have foreknowledge of the fact of the case, when the matter comes before you, you are not supposed to be allowed to adjudicate upon the matter. So assuming you already know about the case, maybe you were even there when the people were even fighting. You saw all of that. You saw how this person punched this person and then all that. And they have brought the case before you. By virtue of the fact that you have foreknowledge of the facts, you are not supposed to participate in the adjudication of the matter. That would be you are likely to be prejudiced because of the things that you already know about the case already. So foreknowledge of the facts precludes a judge from adjudicating upon the case. It will create bias. And the case that I'll use to explain this is the case of Kwame versus Koino. The Kwame in this case is spelled Kwami versus Koino, Quaynor, reported in 1959 Ghana Law Report at page 269. This case lays down the position that foreknowledge of the law in a particular area of law will not mean that you are likely to be biased. That the rule of natural justice says that you should not have foreknowledge of the facts of the case before you. It didn't say that you shouldn't have foreknowledge of the law. And the case is Kwame versus Koino. These are the facts of the case. The essential facts are that when the matter came before the court, one of the lawyers argued that one of the judges, Onenuje, that he was arguing that Onenuje, before coming to adjudicate upon that particular matter, when he was a lawyer and he practiced as a lawyer, he was well versed with issues concerning the Alata quarters 2 land of Osu. Onenuje knew a lot about the Osu Alata quarters 2 lands. And he had even appeared as counsel previously in cases that concerned the Osu Alata quarters 2 lands. And because of that, the counsel for the plaintiff argued that because Onenuje had, when he was a lawyer, done cases concerning the Osu Alata quarters 2 land, and he had even appeared as lawyer for 2 different people concerning lands about the Alata quarters 2 land, Onenuje should not be allowed to participate in the hearing of the case because, according to the lawyer, that amounted to foreknowledge of the facts, which must have influenced his judgment, and that it is not only necessary that justice be done, but it must be manifestly be seen to have been done. So on that basis, he was trying to impugn the judgment. And this is the holding of the courts that can be found in holding 6 and 7 of the head notes. And I quote, that before the decision of a judge can be impugned on the ground of possibility of bias, there must be substantial grounds in support of such possibility. Bare possibility and mere suspicion are not enough. That the fact that Olenude, when at the bar, was specially well acquainted with the Alatakota land and the law relating to it, and appeared as counsel in 2 cases involving such matters, did not amount to substantial possibility of bias, since the parties were not the same parties, nor the land, this land, nor was he previously aware of the facts in the instant case. This is the case of Kwame, Kwami versus Quaynor. Quaynor is spelled Quaynor, 1959 Ghana Law Reports. That if you have foreknowledge of the fact of the case before you, when it is the same parties, the same facts before you, that one, it can be a ground for you to recuse yourself. But when it is not the same parties and you only have foreknowledge of the law, that one will not be a ground of bias. So we have gone through different ways in which a judge can be deemed to be a judge in his own cause. We have dealt with pecuniary interest or financial interest. Once that is proved, you must recuse and decline jurisdiction. We have shown that if you have predetermined the issue, you must recuse and decline jurisdiction. We have shown that if you were the one who had the main case and the appeal has come before you, you must recuse and decline jurisdiction. We have shown that if you have foreknowledge of the facts, you must recuse and decline jurisdiction. Now, the next question is this. When a party alleges bias on the part of a judge, what is the test? What is the test that the court must be satisfied with in holding that a particular judge is being biased? Now, the answer to this question is that when you allege bias against a particular judge, the test is that you must be able to establish a real likelihood of bias and not mere suspicion that a judge is going to be biased. So a mere suspicion of bias, however reasonable that suspicion may be, would not be sufficient. What you must prove is a real likelihood of bias. And the authority for this position can be found in at least 3 cases in Ghana. The cases are Republic versus Constitutional Committee Chairman, ex parte Barima II, in another. Reported in 1968, Ghana Law Report at page 1050. This is the case of Republic versus Constitutional Committee Chairman, ex parte Barima II, in another. 1968, Ghana Law Report at page 1050. You can also see this position in the case of Republic versus High Court, Delu, ex parte Agbesia Owusu II, number 1 and number 2. You see this 2003-2004 Supreme Court of Ghana Law Report on page 864. That says that the test is real likelihood of bias and not mere suspicion. And also the case of Attorney General Ensala. Attorney General Ensala reported in the second edition, the second volume of Jando and Griffiths at page 487. These 3 cases, ex parte Agbesi Owusu II, ex parte Barima Attorney General and Salah, they all lay down the rule that the test of bias is that there must be a real likelihood of bias and not mere suspicion. And the person who has the evidential burden to prove the real likelihood of bias is the one who is alleging the bias against the particular judge. Now, in order to make a strong case to let you better appreciate this test of real likelihood of bias, it will be good to walk through at least two of these cases. And I'll begin with the case of ex parte Barima. The case of Republic versus Constitutional Committee Chairman, ex parte Barima, and another. 1968 Ghana Law Report at page 1050. These are the facts of the case as can be gathered from the headnotes. The applicants applied for orders of certiorari and prohibition to quash certain orders and rulings made by a constitutional committee inquiring into dismissment charges preferred against the Adansehene. The application was grounded on the alleged bias and interest of the chairman of the committee, as well as his, and in quotes, complete disregard for the fundamental conditions of the administration of justice. In his affidavit supporting the application, the applicant deposed that 1, the respondent's wife was related to the people whose complaints resulted in the appointment of the committee. And number 2, that the respondent was intimately involved in the dismissment charges and had made efforts to settle the matter. And 3, the decisions and conduct of the respondents as chairman of the committee showed that he was interested in the disputes and was biased against the applicant. So all the applicant is saying is that he has appeared before the Constitutional Committee that acquired into dismissment charges preferred against the Adansehene. And he's saying that the chairman of the committee, he's saying that he's making a case of bias against the chairman of the committee. And the basis of the allegation of bias against the chairman of the committee are that 1, the chairman's wife was related to the people whose complaints resulted in the appointment of the committee. That the chairman's wife was intimately involved in the dismissment charges and had even made efforts to settle the matter. And that the decisions and conduct of the chairman showed that he was interested in the disputes and was biased against the applicant. That is why the applicant has brought the suit of Republic versus Constitutional Committee Chairman, ex parte Barima II and another. 1968 Ghana Law Report at page 1050. He's saying that based on these, the whole decision should be quashed. This is the holding of the courts. Holding 1, as can be gathered from the headnotes. And I quote, to succeed in these applications, the applicant must show the existence of a real likelihood of bias or interest on the part of the chairman. A mere suspicion of bias, however reasonable might appear, was not sufficient. Since the applicant did not seek to establish that a respondent had a pecuniary or proprietary interest in the matter in disputes, he could not succeed without satisfying the courts that the respondent's interest in the proceedings was so real and substantial and of such a nature as to give rise to a real likelihood of bias. The test of bias in this respect was objective and it was the view that a right-minded person would take if he accepted the matters of fact put forward by the applicants. The respondent's wife had deep roots in Fomena and was connected with a previous Adansehini and the complainant. But this finding was not sufficient to show that the respondent was biased or likely to be biased by virtue of the fact of his marriage to her. And the court went ahead to note that taking all the circumstances of the case and their cumulative effect into consideration, a reasonable suspicion of bias on the part of the chairman had been established. Again, a reasonable suspicion of bias on the part of the chairman of the committee had been established. These circumstances and their cumulative effects did not, however, satisfy the legal standard of a real likelihood of bias. So the court in ex parte Barima has made it clear that in this case, they were able to establish a real suspicion of bias. But that is not what the law requires. The law requires that you must prove a real likelihood of bias. And because they have failed to prove the real likelihood of bias, the court held that they must fail in their action. So the application was dismissed. The application to pass the decision taken by the chairman or the Constitutional Committee was dismissed because the applicant failed to prove a real likelihood of bias. And you realize from this case that proving that real likelihood of bias is not going to be a walk in the park. It's not going to be easy. And so many cases where people allege that they want to prove real likelihood of bias, they end up failing. It is not an easy test to establish because in ex parte Barima, the court even found that there was a real suspicion of bias, but held that that will not be enough because what the law requires is a real likelihood of bias and not real suspicion. It will be important for you to read the case of ex parte Agbesi Awosu II, because in that case, the court found that the real likelihood of bias had been established, and therefore a particular judge was prohibited from going ahead from participating in the hearing of the case. So, ex parte Agbesi Awosu II is one of the very few cases in Ghana in which persons succeeded in proving a real likelihood of bias. So what these cases establish, ex parte Barima, Attorney General, and Salah, and ex parte Agbesi Awosu, what they all establish is that the person who alleges that a judge is being biased is the one that has the burden to prove that the judge is being biased. And the evidential burden is that you must prove on the preponderance of probabilities. You must prove on the balance of probabilities a real likelihood of bias and not mere suspicion. So what we have done so far is to discuss one leg of the natural justice, which is Nemo Judex in Causa Sua, which means that a judge must not be biased. It means that a judge should not have an interest in the outcome of his own case. And so we have looked at different instances where that can apply, and we have seen the tests that must be established before a person can be held to be biased. We've looked at who has the responsibility of meeting that particular standard. And we know that once a judge is biased, then the whole decision becomes void. You remember what we saw in Dimes and Grand Junction Canal. Even the Lord Chancellor, because he had a small financial interest, shares in the company, the court felt that they had to quash it to serve as a lesson to all courts. Now, it will interest you to know that there are some exceptions to this particular rule. There are some exceptions to this rule of Nemo Judex in Causa Sua. There are some exceptions to the rule against bias, meaning that there are times when a particular judge may be found to have a particular interest or he may have been deemed to have maybe presided over a case, but he'll still be allowed to perform some rules in that particular case. And we'll go ahead. The first exception we shall look at is when the judge has a statutory duty to perform. Now, what you should remember is that this principle of Nemo Judex in Causa Sua, it is an offshoot of the common law. And so, if it comes from the common law and then a particular judge has a statutory duty to perform, it means that you are relying on the common law to tell the court that the court should not be allowed to participate. The judge should not be allowed to participate in the hearing because of the common law or any equitable principles that you are relying on. And the question would be, when the principle of equity conflicts with the statutory duty, the law is that we will allow the statutory duty to prevail. And I shall use the case of Akufo-Addo and others versus Kwasi-Aidan and others to explain this exception. The case is Akufo-Addo and others versus Kwasi-Aidan. Kwasi-Aidan is spelled Quarshie. Aidan is spelled Idun and others. Reported in 1968, Ghana Law Reports at page 667. Now, this is what happened in this case. The Chief Justice at the time had issued a circular to lawyers. And some lawyers were not happy with the circular that the Chief Justice had issued. So the plaintiffs in this case brought an action. They sued the Chief Justice, they sued the Judicial Secretary, and they sued the General Legal Counsel. So 3 defendants. They have sued the Chief Justice, they have sued the General Legal Counsel, they have sued the Judicial Secretary. And then, when the matter came before the court, by law, the Chief Justice is the one that has the power to empanel the judges. So, they objected that since they are challenging a circular that the Chief Justice issued, the Chief Justice should not be allowed to constitute the judges. He should not be allowed to constitute the bench. Other than that, according to them, he can easily decide to empanel people that will do his bidding. So since they are challenging the actions of the very Chief Justice, he should not be allowed to do the empanelment. Now, this is what the court said in holding 1 of the appeal. That the function of the Chief Justice was to constitute the benches of the Court of Appeal. As long as he remained in office and in the country, he performed that as part of his administrative duties. And where a statute enjoined a person to perform an act, he had to do it, even if its performance conflicted with the rules of natural justice. So the court has held that when the principle of natural justice is conflicting with the performance of a statutory obligation, then they will go ahead and violate that natural justice doctrine. And the Court of Appeal in this Akufo-Addo and Kwasi-Aidan case, they relied on the case of Dimes and Grand Junction Canal Company Limited. You remember Dimes and Grand Junction Canal? What the people were challenging was a conduct of the Lord Chancellor himself. And he had to sign some things before the appeal could be heard. So, what did the court hold? That, of course, that was a statutory duty, and he could perform it. So, all we are saying under Akufo-Addo and Kwasi-Aidan is that the Chief Justice is the one who released the circular, and he's the one that has been sued. So, if they have sued him, can he go ahead and do the empanelment? The court is saying that since that is his duty, statutory duty, he can go ahead and perform it. The same principle has been applied in the case of Chakchuchikata versus the Chief Justice and Attorney General, reported in 2001, 2002 Supreme Court of Ghana Law Reports at page 437. In this case as well, the suit was brought by Chakchuchikata against the Chief Justice and Attorney General. And once again, because the Chief Justice was a party to the suit, he raised an objection that he should not be allowed to perform the function of empaneling the courts. Courts in this case held that since it was a statutory duty of the Chief Justice to do the empanelment, he could go ahead and still do the empanelment, even if doing it is going to conflict with the principle of natural justice. So in all these cases, you can see clearly that when you bring an action against a person and the statute requires him to perform an administrative or ministerial function, you cannot use natural justice as a basis to prevent him from performing that administrative or ministerial function. The final case on this exception that I'll use is the case of Ajiechum versus Attorney General. Ajiechum versus Attorney General and another is reported in 2005-2006 Supreme Court of Ghana Law Reports at page 732. And in this case, the court also held the same position that once the statute or the constitution requires the Chief Justice to perform a statutory or administrative function, he can still go ahead to perform it, even if the performance is going to conflict with natural justice. Because remember, this Nemo Judex in Causa Sua rule is from the court of equity in the common law. This case is so crucial because in this case, a petition had been sent by Mr. Baitakwete for the removal of the Chief Justice from office. That is how serious it was. A petition for the removal of the Chief Justice. And then when there was an issue about whether or not they had to establish a prima facie case. So when Baitakwete sent the petition to remove the Chief Justice, an action was filed by Ajiechum at the Supreme Court, saying that the procedure that had been used by the president for the removal, was not in consonance with the Constitution. So out of the petition, an issue has come to the Supreme Court. And who has to do the empanelment? The very person who you want to remove is the one that has to do the empanelment. So as expected, an objection was raised that the CJ should not be allowed to do the empanelment because allowing him is going to bring bias. Now, is it really the case that if the Supreme Court judge, the Chief Justice empanels Supreme Court judges, they're going to be biased? Is that really the case? Can it be the case that because the Chief Justice has them, are you saying that the Chief Justice do not have their own mind of their own? Let us see what the Supreme Court had to say in Ajiechum and Attorney General. Because of how important it is, I'm going to read relevant portions of the judgment of Dateba GSC. And I'm quoting from the dictum of Dateba GSC. Without suspension, which the president has not carried out, it is an uphill task to seek to prohibit a serving Chief Justice from constituting the panels of the Supreme Court, even if the exercise of the function gives an impression of a conflict of interest. An explanation for the reluctance by this court and its predecessors to interfere with this function of the Chief Justice is probably to be found in the judicial oath of the judges. Supreme Court judges are not malleable clay in the hands of the Chief Justice. The judges of the court are likely to believe that whichever of their number are empaneled will act independently. Therefore, not too much hangs on the exercise of this ministerial as contrasted with the judicial power of the Chief Justice. Emisa J.A. as he then was, makes a similar point in Akufo-Addo and Kwasi 1968 Ghana Law Report at page 667, where he says as follows, and I quote, "Judges are sworn to do justice between the parties without fear or favor. This oath transcends mere invitations or even appointments to sit in a particular case. Were it otherwise, no one would dare fear from fear of bias to bring an action against government, because the very appointment of the judges is made by government." Quote ends. So that's a quote from Akufo-Addo and Kwasi. But this quote is being made in Agyetum and Attorney General. So I'm going ahead to still read the dictum of Dr. Ban GSC in Agyetum and Attorney General. The principle laid down in the Akufo-Addo case was that where the common law principles of natural justice conflict with the mandatory statutory provision, the statutory, or by implication, constitutional provision prevails, even if it results in non-compliance with the rules of natural justice. This position is justified by reference to the doctrine of necessity. In that case, Emisa J.A. delivering the judgment of the full bench of the Court of Appeal said as follows, and I quote, "In our opinion, where a statute clearly enjoins a person to perform an act, he has to do it, even if its performance is incompatible with the strict rules of natural justice." And the quote ends over there. So what we can see from Agyetum and Attorney General is that they have reaffirmed the long line of cases from Akufo-Addo and Kwasi, from Chikata versus the Attorney General and the Chief Justice, from Dimes and Grand Junction Canal, that if the performance of a statutory duty is going to conflict with natural justice, will still allow the Chief Justice to perform the statutory duty of the empanelment. That is one of the exceptions to the Nemo Judex in Causa Sua rule. One, where there's a statutory duty, and you have several cases for that. You have Akufo-Addo and Kwasi, you have Chikata versus the Attorney General and Chief Justice, you have Agyetum and Attorney General, and you have Dimes and Grand Junction Canal. Second exception is the doctrine of necessity. That is to say that if complying with the rule means that the case cannot be heard, then it means we cannot insist on the principle. If insisting on the rule means that there is not going to be any judge to adjudicate upon the matter, we will dispense with that natural justice principle and rather allow the judges to adjudicate upon the matter. And on this, I refer you to the cases of Marbury and Madison, and I also refer you to the case of Bilson versus Apalu, reported in 1981, Ghana Law Report at page 15. And in this case of Bilson and Apalu, 1981, Ghana Law Report at page 15, this is the holding of the courts as captured in the head notes. And I quote, "The rule of natural justice, Nemo Judex in Causa Sua, also known as the rule against judicial bias, arose in two ways. One, where the adjudicator was disqualified because he had direct financial or proprietary interest in the subject matter of the suit, and where there was a real likelihood that the adjudicator would be biased in favor of one of the parties. There were, however, three situations where the presence of any of the said disqualifying elements under the rule would not render the adjudicator incompetent to sit. A, it was always open to the parties on their being apprised of the disqualifying elements to waive their right to object to the adjudicator in a particular case. B, An enactment might permit an adjudicator to sit or might save the adjudication from invalidity. And C, an adjudicator who might be otherwise disqualified would be nevertheless eligible and indeed obliged to sit if there was no other competent tribunal or if the quorum would not be formed without him. The policy reason underlying that exception was necessity. In other words, the common law considered it expedient that justice should be dispensed even by a disqualified judge than that there should be a failure of justice or that the machinery of justice should grind to a halt in a particular case. In the instant case, natural justice had to yield to necessity, since otherwise it would be impossible to constitute a quorum of high justices of the Supreme Court for hearing of the case under Article 115 of the 1979 Constitution. And it goes ahead to say that this is a proper occasion calling for the invocation of the doctrine of necessity to prevent a failure of justice, the allegation of bias against the two justices notwithstanding. So it means that if applying this whole thing of natural justice is going to grind the whole justice machinery to a halt, such that they cannot even give any quorum to give a decision, we will forget about natural justice and rather allow everybody to preside so that we can have justice. So we have seen two exceptions so far to the principle of Nemo Judex in Causa Sua. We have seen one, when there's a statutory obligation that has to be performed. Number two, we have seen that out of the doctrine of necessity. The third exception is acquiescence or waiver. It was even mentioned in the case of Dilson and Apalu, that if it comes to your attention that a particular judge is being biased or has a tendency of being biased, let's say he has a pecuniary interest and you are aware of it and you keep quiet, you'll be deemed to have slept on your rights and you cannot later come and complain about the procedure. So these are the three exceptions to the Nemo Judex in Causa Sua rule: statutory duty, acquiescence, and then also when under the doctrine of necessity. This brings us to the end of our lecture on natural justice, specifically Nemo Judex in Causa Sua and its applicability in Ghana.